Hearing in the appeal BPP Holdings Limited and others against Commissioner for Her Majesty's Revenue and Customs.
My Lords, I appear with Mr. Nicholas Gibson for HMRC and Mr. Grzyński appears for BPP. My friend repeatedly says that the Court of Appeal's judgment under appeal today is unimpeachable. I have no doubt, my Lords, that the Court of Appeal is at all times and in all cases unimpeachable. However, that is not to say that it is always correct, and we submit that it erred in this case. The upper tribunal, having examined all the facts over a period of 2 full days and giving its decision only 5 days later, concluded that once one applied either the test set out in Data Select or the principles in Denton, HMRC's breach was not so serious as to warrant barring. And you have an email on your desk, which we referred to in the chronology, but is not in the papers, which is the initial decision of 20th of October, and you will see that Judge Bishop says HMRC are not barred by reason of failure to serve an adequate reply as the failure is not sufficiently serious. And then at paragraphs 62 and 59 of the decision, MS 195 to 196, the upper tribunal was clear that it was manifestly not warranted. The upper tribunal was clear that it was only once one applied Mitchell prior to Denton that the barring order could conceivably have been justifiable. And the upper tribunal found that the first tier had applied the wrong principles, had failed to take into account relevant considerations, for example, the availability of costs as a sanction, and it concluded that overall the FTT was manifestly wrong. That is, its decision was legally erroneous. The Court of Appeal, producing its judgment 2.5 months after the hearing, and without the benefit of reviewing the facts in any detail, held that the upper tribunal had exceeded its appellate jurisdiction. It did so by simply ignoring what the upper tribunal had done, and indeed the fact that once one applied Denton, the barring order could not be justified, saying in its words that that was to put the cart before the horse. That's paragraph 34 of its decision, MS 175. With respect, that was not right. Even assuming the principles are those in the new CPR 3.9, the horses that pulled the cart had to be the Denton breed.
Well, sorry, why do you assume that the principles are those in the CPR?
Sorry?
Why do you assume that the principles in the tribunal rules are those in the CPR?
I do not. I'm proceeding on the basis of the Court of Appeal's approach. And indeed, our submission is that Data Select was the correct test, as Judge Bishop provided, i.e. the tribunal rules, or alternatively, if you're going to apply the CPR, then 3.42C. Now, we say the upper tribunal was right, assuming the CPR applies, to have analysed the facts through the lens of Denton as well as Data Select, and it was not open to the Court of Appeal to overturn the upper tribunal's decision that applying those principles, the barring order was manifestly not justified.
What is the proposition that you extract from Denton, which you say is decisive?
There are 2 key propositions for the purposes of this case. The first is that the trivial test in Mitchell is replaced with serious and significant, and I'm going to take you to that. And in this case, Judge Bishop specifically held, as I showed you, it was not sufficiently serious. That's part 1 of the Denton test. And then part 3 of the test is looking at all the circumstances, which Judge Bishop also did, and concluded that, for example, the failure to take into account the possibility of costs being a sanction, or indeed the FTT believing that that was not available to it, was in fact a relevant consideration. Looking at it overall, in all the circumstances, barring was not justified. So basically, principles 1 and 3.
These look like factors going to, essentially, to weight. I mean, what we're really asking ourselves, surely, is whether there was something wrong in principle about the first-tier tribunal decision, not whether there was something wrong in principle about the upper tribunal decision.
Well, irrespective of whether that is the case, there is something wrong in our submission with the first-tier tribunal, because it considered that it had to give significant weight to the two factors in CPR 3.9 and 1.12F of the new CPR.
So in particular, it thought that it had to give significant weight, I think this is your case, to the importance of enforcing compliance with orders.
Precisely.
But are you seriously suggesting that that is a novel principle which should have no place in a discretionary decision of this sort?
No, my Lord, we obviously accept the need to ensure compliance with rules is always going to be part of an analysis.
Even before Mitchell?
Even before Mitchell. The difference is that the amendment to 3.9 and the overriding objective in the CPR by the 2013 changes had a significant effect, and more importantly was intended to have a significant effect. And it was that change that was applied by the first-tier tribunal. And I'm going to come to whether one should assume, as the Court of Appeal did, that in fact there was no need ever for any amendment to the CPR, because that is effectively what they are saying.
But the issue in your submission is really the amount of weight that you attribute to the need to enforce the court's orders.
Well,
You accept that there was always going to be some weight, but you say too much.
Well, no, our submission is not that the FTT applied too much weight, but rather it considered that it was obliged to give so much weight as it gave, when in fact the position should be that it weighs all the circumstances, including the obvious need to ensure compliance. So turning to the issues before the court, it's essentially being asked to determine which of two approaches should be taken to an application by a party to strike the other side out for default of an order prior to a first instance hearing in the tribunal system. And evidently this has wider implications than this case, but this case is of course important. We say that the approach the Court of Appeal laid down, namely denying a litigant its right to argue a case even where costs could wholly remedy the prejudice, in its words, the correct starting point is compliance, unless there is good reason to the contrary, which, if possible, should be put in advance to the tribunal, and that's paragraph 38 of its judgment, MS 175, was not the correct approach and was apt to create injustice, including for the public at large. It essentially involved the application of the Mitchell and Durrant relief from sanctions test before it was modified in Denton. And this, moreover, in a case where the breach had no automatic consequence. In our submission, the upper tribunal approach, namely a proportionate, balanced approach that looked at all the circumstances of the case in accordance with the rules, including the nature and extent of any prejudice and the availability of alternative sanctions, was the correct one. We say that such a proportionate, balanced approach is reflected in any of three tests. Either the modified data select test that Judge Bishop set out in the Leeds City Council case and applied here, or the test, analogous test in CPR 3.42c, or indeed the three-stage Denton test, which applies to the new CPR 3.9. Now, I note briefly here that my friend seeks at paragraph 4 of his case to summarise what he says is our prolix case, and again, in his words, in three retrogressive and surprising propositions. For the avoidance of doubt, those propositions are not HMRCs. One need only go to his cross-references to expose this. Indeed, throughout his case, my friend claims that HMRC makes submissions that it simply does not make. For example, that the tribunal should never have regard to the CPR, that the upper tribunal can't give guidance, that compliance with rules is not a factor to be given weight, and that a more lenient approach should be given to Her Majesty's government. HMRC does not and has never made such arguments, and I only raise this because the Court of Appeal judgment is very largely based on BPP's skeleton, which contains similar errors. BPP also claims at paragraph 38 that HMRC repeatedly argues that there was no prejudice. This is incorrect. HMRC accepts that the prejudice was delay to BPP, delay in relation to facts that it sought to have set out in a single document, and the associated costs of obtaining those facts. And the references are the Upper Tribunal Judgment 24, 52, 59, and 64, and the First Tier Tribunal 73 to 74, 83, and 100. BPP described the prejudice it suffered as, in its words, delay in getting its VAT status determined, and that's at paragraph 57 of the Upper Tribunal judgment. But as Judge Bishop said, nothing prevented the hearing from going ahead in November, it having been fixed in March. The breach was remedied on 16th of June, that is a week before the barring hearing, and the facts were agreed between the parties on the 27th of June before the barring order was made. As Judge Bishop stated, therefore, the breach could be remedied in costs, and the First Tier Tribunal had been mistaken in thinking it couldn't do so, and that's 63 and 64 of the Upper Tribunal judgment. Turning then to my submissions, I'm going to firstly deal with the background, then I'm going to take the court to the Mitchell-Denton-Durrant point. Secondly, I'm going to deal with CPR 3.42c. Thirdly, I'll deal with the question of whether it's acceptable to transfer the new amendments into the tribunal rules. If I have time, I will touch on data select. And finally, I will deal with BPP's approach to the Court of Appeal's fundamental errors of fact. So the background. My Lords, before the First Tier Tribunal, BPP has challenged HMRC's determination as to the VAT status of its supplies. The case would have been heard on the 17th of November 2014 had it not been for BPP's decision to appeal to the Court of Appeal on 30th of October 2014. The FTT would have determined BPP's appeal de novo and on the basis of a statement of agreed facts between the parties of 27th of June, which can be found at MS 866 to 877, and then the agreed issues in the following tab. If the case is ever heard, the First Tier Tribunal will decide whether BPP's supplies of books, normally 0 rated, and education services, standard rated, are both standard rated as a result of an amendment to the law which had effect from 19 July 2011 and was brought in by Section 75 of the 2011 Finance Act. And you can find that provision in the supplementary bundle. I'm afraid the wrong one was put in the core bundle, so it's in the addendum. It's at MS4. The law was changed to deal with situations where a business restructured so as to make supplies through different companies and thereby avoided being assessed as a composite supply by one company. This was what BPP had done by restructuring in 2006. On the advice of PwC, BPP accepted that after the change in law, its supplies of books and education were standard rated, even though the supplies were made by different companies. And the reference for that is MS 530. However, a year later, in September 2012, BPP suggested that perhaps that interpretation was not correct, and that's at MS 544. HMRC then decided that BPP was correctly standard rating its supplies, and that is what it has done. And the best place perhaps to see the relevant decisions, if my Lords could turn to the chronology, which is in the core volume at MS 110. The relevant decisions, I can give you the MS numbers for. It's at 11th of October 2012, so MS 111. And that decision is at MS 554. There is then a decision letter of 6 December 2012, and that's at MS 581. There is then a decision of 19th of March, which is on the following page. And finally, there is a review decision on 17th of June 2013. So those were the detailed decisions of HMRC as to why the supplies were standard rated. Now, BPP has made voluntary disclosures, that is, it has claimed back the VAT that it has charged customers from HMRC, amounting to 8.25 million, which is the period from July 2011 to August 2015. You have one of them in the bundle, the other is now on your desk. If the same level of sales continues, then to date we expect a reclaim of VAT charged and accounted for to HMRC of £12 million. So if BPP succeeds in its bid to have HMRC barred and HMRC's defence is struck out, BPP may obtain that money back from the revenue without a merits hearing or following an inadequate one. It looks to gain a significant windfall. BPP could potentially also obtain a future tax advantage over its competitors. Now, its answer to this is that that is too bad, that the FTT decisions are not binding and that other people in its situation can be assessed differently from it.
It's not its only answer. I mean, it also says that to describe it as a windfall is really begging the question.
Well, it's a risk, of course, that if HMRC cannot serve its function of ensuring that BPP puts all the facts in front of the tribunal and the law is put in front of the tribunal so that the tribunal can de novo take a decision as to the status of the supplies, there is a risk that BPP obtains a windfall. That risk, of course, is made good if, in fact, the first-tier tribunal actually gives summary judgment without assessing the merits at all. Now, there is a reason why BPP has been willing to expend £250,000 of legal costs up to the Court of Appeal hearing and lose its hearing date of 7 days before the first-tier tribunal back in November. The prize is a big one, particularly, we say, as its chances in this appeal are low.
Is it proper for us to consider the chances of the appellant in that appeal?
Well, my lord, I refer you to the Hissage case, which at paragraph 47 says that only in those cases where the court can see without much investigation that the grounds of appeal are either very strong or very weak, will the merits have a significant part to play when it comes to balancing the various factors that have to be considered at stage 3 of the Denton process. In most cases, the court should decline to embark on an investigation of the merits and firmly discourage argument directed to them. So only if my lords are satisfied that it is pretty obvious that their case is weak, is it right for you to take it into account.
Is that going to be your submission?
Yes, that is our submission. And indeed, as I've said, for a year, on the advice of PwC, BPP has standard rated it, and it's continued to standard rate its supplies. If it was sure of its case, it might not have proceeded in that way.
The fact that you change your mind doesn't mean to say that you are unsure of the correctness of your second opinion.
No.
Anyway, it's not what they think about their case. If this point is relevant, it's what we think about it.
Yes. So the first point, whether it was decided, the fact that the FTT decided the case before Denton. Now the dicta, FTT based its case on binding dicta in McCarthy and Stone, which applied Mitchell and Durrant before it was modified in Denton. As Judge Bishop held, this was not the first-tier tribunal's fault. And if I can take you to the upper tribunal decision,
Yep.
it's in MS 190, I'm using the core volume.
That's fine. Which paragraph?
Paragraph 39.
Thank you, yes.
So, my lord, halfway down at 40, Judge Bishop says, Judge Mosedale could not have taken either Denton, in which the judgment was handed down on 4 July, or my decision in Leeds, which is where he applies data select, which was released on 29 July into account. I therefore proceed on the footing that, insofar as she did so, Judge Mosedale was wrong to base her conclusions on Rule 3.9 and Mitchell, That is not to be taken as a criticism of her. At the time the application came before her, she was bound to adopt that course by virtue of what this tribunal had said in McCarthy and Stone. Now, the approach as expounded in Mitchell, Durrant, McCarthy and Stone was that relief from sanctions should be refused unless the breach was trivial and there was good reason, meaning something outside the party's control. And because of the time, I'm only going to give you references to that. The Mitchell case is at Authorities 1, tab 13, and the relevant paragraphs are 40 to 41. That's MS 1251. The Durrant practice note is at Authorities 1, tab 14, paragraphs 39 and 41. That's MS 1265. And the McCarthy and Stone case is at Authorities 1, tab 15, paragraphs 45 to 48. Now, this is in effect the test that the Court of Appeal expounded in its judgment in this case. Namely, the starting point is compliance absent good reason. And I can take you to the Court of Appeal judgment. It's in the core bundle and MS 175 and paragraph 38. The court says a more relaxed approach to compliance in tribunals would run the risk that non-compliance with all orders, including final orders, would have to be tolerated on some rational basis. That is the wrong starting point, and this is the test. The correct starting point is compliance, unless there is good reason to the contrary, which should, where possible, be put in advance to the tribunal. Now, we struggle rather with the first sentence of that paragraph. We thought maybe the word rational in the third line should be replaced with irrational, but we don't think that that works either. Evidently, if something is done on a rational basis, one might expect it to be correct. The Court of Appeal, we say, entirely ignored that this was the test set out in Mitchell and Durrant, applied in McCarthy before its further modification in Denton. Now, BPP denies that, and it says that the Court of Appeal took into account the Denton test, and it refers you, at paragraph 85 of its case, to paragraphs 16, 26, 34 and 37 of the judgment. Now, none of these paragraphs support its claim. In particular, in its objection to our notice of appeal, it actually cited paragraph 37 to support this proposition. If I can take you to that, it's at MS 56, paragraph 5. So BPP says further, HMRC mischaracterised the Court of Appeal's judgment by suggesting that it applied the Mitchell approach before its further explanation in Denton. That is not what the Court of Appeal decided, and then it gives the example, paragraph 37, which it quotes. To put it plainly, there is nothing in the wording of the overriding of the tax tribunal rules that is inconsistent with the general legal policy described in Mitchell and Denton. Well, with respect, that does not answer the point, because there may be nothing inconsistent between the tribunal rules and the test as expounded in Denton, but the simple fact remains that the Court of Appeal applied the Mitchell test, not the Denton test, and that...
In a sense, this is all very theological. We're ultimately concerned with whether Judge Mosedale's decision can stand, aren't we? Whether the Court of Appeal was right or wrong, that's the ultimate decision here.
Well, whether...
And in a sense, what she approached it, I think, again, you can say this may be wrong, she approached it on the basis of her conclusion on the principles in paragraph 65 on page 272, didn't she? I conclude that in considering whether to grant the appellant's application to bar HMRC, I must consider all relevant factors. I will include in my consideration factors A and B in CPR 39 and accord them significant weight. Isn't that really the nub of what she cited with her approach?
Yes, it's 63, 65 and 96. 96, while the factors identified in Mitchell are not directly relevant for the reasons I have given, I have to give significant weight when considering the overriding objective to the importance of compliance and directions of the tribunal and avoiding unnecessary delays. So what she was doing there, and what Judge Bishop found she was doing there, is doing what she had to do, which was apply McCarthy and Stone. And I've given you the reference. McCarthy and Stone directly applies Mitchell and Durrant.
Looking at applying Mitchell, Durrant, McCarthy and Stone, we've got to ask ourselves what she did. Was that wrong? And did she approach it wrongly in principle? And if she didn't, then did she reach a conclusion that no reasonable judge in her position could have reached? Those are really the two questions.
Yes, and that's exactly what Judge Bishop did.
Yeah.
He concluded that both that she had approached it wrongly because she was not obliged to give significant weight to the new amended CPR, and secondly, that in any event, looking at all the facts and circumstances, the barring order was manifestly not warranted, i.e. was unreasonable.
You are not reading more into I have to than the judge really intended. Is she, in fact, expressing a rule of law there, or is she simply saying she has to give significant weight to it because it warrants it, having regard to the points made in the second half of that paragraph?
Well, my Lord, I submit that Judge Bishop was correct, because one has to recall the context of this, which was McCarthy and Stone, which you'll no doubt have time to go to, which specifically applies Mitchell and Durrant to show that things have changed. And indeed, if one looks at her judgment in the first-class communications case, which is in your bundle, you'll see that she's approaching the 8-3 discretion before Mitchell completely differently. So what she is doing here is saying things have now changed. I am bound by McCarthy and Stone, and I think that's clear. I submit that's clear from 63 and 65. And Judge Bishop said that she was right to consider herself bound by McCarthy and Stone, because it was an upper tribunal decision binding on her, and it preceded his decision in Leeds.
Is there anything wrong with her taking the view that when considering the overriding objective in the tribunal procedure rules, she ought to give significant weight to the importance of compliance with the tribunal's direction and avoiding unnecessary delays and expense? It seems obvious common sense.
Well, of course, it's common sense that it plays a part in any analysis of any breach by any party. But if one, and I am going to take you to the first-tier tribunal rules, if one looks at the first-tier tribunal rules, first of all, you see that that particular requirement is not one of the necessary requirements, and therefore, in a sense, they are all necessary. Each of the requirements that are set out, she is obliged to take account of. There is no, as Judge Bishop said, there is no requirement to give significant weight, as there is in the CPR, to that factor, insofar as so much weight must not be given that it has the effect of breaching the overriding objective, which is what Judge Bishop found. He found that the overriding objective was manifestly not met by a barring order in this case. Now, I was going to...
Are you saying that she erred in attaching significant weight to the two factors that she mentioned?
I am saying she erred in believing that
she was obliged to.
That she was obliged to, and therefore not addressing it.
I mean, unless it was an error to attach weight to the factors, does it matter that if she mistakenly thought that she was bound to?
Yeah, because if she had approached it prior to McCarthy and Stone, she would have approached it on the basis of the first-tier tribunal rules and the overriding objective as set out there. And indeed, Judge Bishop believes she should have approached it from a data point of view, but certainly having regard to all the factors set out there. So she would not have taken the same approach. And the fact that that is made clear by the fact that prior to Mitchell, in first-class communications, she took the normal approach in the tribunal. Now, we say it's clear that Denton modified the approach set out in Mitchell, and perhaps this is not in dispute, but we better briefly go to Mitchell. It's in the Authorities Bundle 1, tab 17, and, my lords, if you could read the first bit of the head note, crucially at F.
Sorry, which tab?
Tab,
This is Denton.
tab 17.
That's Denton, not...
Denton, that's right.
Sorry, you
Sorry.
want us to go to Denton, not...
Yes, Denton, please.
It's the head,
I've
note,
given
the head
you-
note at 1236 at letter F.
1326, yes.
1326, yeah.
1326. So we have the head note which sets out the Lord Dyson's modification of the judgment in Mitchell. And in the middle of that head note, the focus of the inquiry at the first stage should be not on whether the breach was trivial, but on whether it has been serious or significant. And you'll recall that email. And then paragraph 3. The correct approach to the application of this rule has given rise to much litigation and debate among practitioners. In the light of this, the court invited the Bar Council, etc. Next page. We're grateful to them, as well as the representatives, for the reasons that we give later in this judgment. We think that the judgment in Mitchell, the case, has been misunderstood and is being misapplied by some courts. It's clear that it needs to be clarified and amplified. And then, if my lords could sideline paragraph 24, and then read the first half of paragraph 26 down to C, I would emphasize the section at B.
Yeah.
So it seems that the word trivial has given some rise to difficulty. For example, it has given rise to arguments as to whether a substantial delay, and here the delay could be said to be substantial, in complying with the terms of a rule or order which has no effect on the efficient running of the litigation, is or is not to be regarded as trivial. Such semantic disputes do not promote the conduct of litigation efficiently and at proportionate costs.
So what's the test? Significant weight, is it?
This brings
That's
in
the
a
very
test.
that's the
What
very
makes it
test. That's the
trivial-
very test that Judge Mosedale applied, didn't she?
No, this replaces, so the test in Mitchell was, is it trivial? If it's not trivial, relief from sanctions refused unless...
But she said that the test was that you had to give significant weight. Now, that might not have been the test, but it was the test after Denton.
No, she said you had to give significant weight to the need to ensure compliance with rules. Yeah. What Lord Dyson is saying here is that the triviality test in Mitchell, so if not trivial, there must be a good reason, which must be something outside of your control, no longer applies. The first stage of the test is it significant or serious? And Judge Bishop found it was not sufficiently serious. That is a very different first stage, and you don't even need to go on to the third stage, which is all the circumstances. Then, my lords, 27, 3 lines down, the assessment of the seriousness or significance of the breach should not initially at least involve consideration of other unrelated failures that may have occurred in the past. At the first stage, the court should concentrate on an assessment of the seriousness and significance of the very breach in respect of which relief from sanctions is sought. And then, if you could sideline paragraph 29, which is just reasons, and then read paragraph 31, which explains the importance of the misunderstanding following Mitchell.
In paragraph 32, it strikes me as being very similar to what Judge Mosedale said. Just above letter C, it's referring to factors A and B in in CPR 3.9, although the two factors may not be of paramount importance, we reassert that they are of particular importance and should be given particular weight when all the circumstances of the case are considered.
Yes. And we say that Judge Bishop, re-looking at all the facts in the light of the new test, took the view first that stage 1 of the test was met, but secondly, in any event, looking at all the circumstances, stage 3 was not met either. Then, my lords, so I've closed that. If you could go to paragraph 37 and 38, and either sideline or quickly read that. And then Lord Justice Jackson, in the minority, propagating a more lenient test at 84 to 86 and 95 to 96. Now, for the court's notes, there is a note in the rule book, in the White Book, about the changes post-Mitchell, explaining the problems that Mitchell caused, and that is at MS 414, above 3.94, and we ask you also to read 3.9.44 on the following page.
Sorry, could you give me the reference again? I'm so sorry.
Sorry, it's MS 414, it's a note above 3.9.4.
MS 414.
Yes. And then on the following page, the paragraph 3.9.4.4. Now, the approach taken by the upper tribunal in this case is the same as the approach taken by the Court of Appeal in other cases. And I give you two examples. First, the Patterson case, which is Authorities 2, tab 38, MS 1602. And secondly, the Wilson case, which is Authorities 2, tab 31. In both those cases, the Court of Appeal noted that the lower court had applied the Mitchell test, Denton had then been released, and the court reassessed the facts by reference to Denton.
It's interesting, isn't it, that in Denton, all three members of the Court of Appeal, including Lord Justice Jackson, who, as you say, would have favoured a more lenient test, thought that the Mitchell decision was actually right.
Exactly. It had been misunderstood.
Misunderstood.
Yes.
So what was a pretty tough decision on any view was nonetheless upheld.
Yes. And the notes that I referred to also explain that. Now, sorry. So just to say that the Court of Appeal in in several other cases, but the cases I refer you to, Patterson and Wilson, did the same thing. It said that the High Court had made a decision on the basis of the Mitchell test. It looked at all the facts again in the light of the Denton three-stage test. Now, BPP answers this at paragraph 87 of its case by trying to distinguish the facts of those cases. We say it does so inaccurately, but in any event, whether or not the facts can be distinguished is irrelevant to the principle, which is that it is proper for the appellate court to reassess all the facts by reference to the appropriate three-stage Denton test. And that's what the upper tribunal did in this case, and the Court of Appeal did in Patterson and Wilson. So we say the Court of Appeal in this case was wrong to say that the upper tribunal did anything it should not have done, i.e. acted entirely properly within its appellate jurisdiction, as explained in the Biguzzi case, Authorities 1, tab 4, 1298F, per Lord Wolfe, that's MS 1096, and in the Carlco case, Authorities 1, tab 6, paragraph 19, MS 112, Simon Brown, Justice. Even assuming significant weight is given to the need to comply with rules, orders, and practice directions, the upper tribunal held that applying stage 1 of the Denton test, the breach was not sufficiently serious to warrant barring, and having regard to all the circumstances of the case, barring was not warranted. Now, BPP says that Judge Bishop, in fact, gave paramount importance to the revenue being able to participate, and it says that at 90, subparagraph 2 of its printed case. We say, in fact, that was explicitly rejected by the upper tribunal, and that's the last sentence of paragraph 58. What the upper tribunal said was the most compelling factor was that the trial could take place without any unfairness, and that's paragraph 62. And it noted that the prejudice to BPP was real but not great and could be remedied in costs, contrary to what the first tribunal had said, and that's paragraph 63 of the judgment, the decision, I should say. Turning then to point 2, our second point is that in any event, this is not a relief from sanctions case. It is more appropriately, if you're going to draw an analogy with the CPR, the analogy is 3.4. Now, the Court of Appeal recognised that this is not a relief from sanctions case at paragraph 8 of its judgment, but it wholly failed to address the consequences of that, namely that a different test applies from that in paragraph 3.9, and arguably that the correct analogy is 3.42c, whether one takes 3.42c before the change of the overriding objective in 1.12f or afterwards. Indeed, the Court of Appeal derided HMRC's suggestion to that effect at paragraph 36 of its judgment. Now, we make 4 points. First, in civil proceedings, many rules have automatic consequences. For example, the Mitchell case was a costs rule. In all those cases, relief from sanctions is required, and that's set down in Rule 3.8, which can be found as MS 410. The position in the first-tier tribunal is somewhat different, and I want to take you to Rule 7. It's in the addendum to the core volume at MS 11, the tiny bundle. I'm afraid only half the rules got into the main one. And you'll see on page 11 that 7.1 provides an irregularity resulting from a failure to comply with any requirement in these rules, a practice direction or a direction does not, of itself, render void the proceedings or any step taken in the proceedings. Now, in the FTT, there are only 2 circumstances where a breach of a rule has an automatic consequence. The first is where an unless order has been imposed under Rule 8.1, which is just there in front of you. The second is where there is a time limit for making an application for permission to appeal, and you can find that in Rule 39, which is on page 24. MS 24, 39.4, if the person seeks permission, then 39.4b, unless the tribunal extends time for the application under 5.3a, the tribunal must not admit the application. So it has an automatic consequences. It follows that by providing an order under Rule 8.3a, if we go back to page 11, you'll see 8.3a, what Judge Hellier did was effectively afford the first-tier tribunal the power that the civil courts have at all times under Rule 3.42c. Now, crucially, Judge Hellier refused BPP's application for an unless order. This was because such an order was wholly unwarranted. HMRC had agreed on the 17th of December to provide the information requested by the 31st of January. HMRC had provided its full disclosure on the 17th of December, BPP asking for a 60-day extension at that point. It is true that HMRC had served its statement of case 14 days late, but it had applied for an extension of time as provided for in Rule 25. Rule 25 specifically provides that you ask for it at the time. And BPP did not oppose that application, and that is recorded in the upper tribunal decision at paragraph 5, MS 182. Accordingly, there was no basis on 9th of January to suggest that HMRC had done anything wrong or would do anything wrong, which could conceivably, at that stage, have warranted an unless order. Fourthly, it follows that if the FTT is to apply the CPR by analogy, then the relevant question is whether, in an equivalent civil case, the civil courts would strike out a defence. And we submit that in the circumstances of this case, the civil courts manifestly would not have struck out HMRC. And we say that this is so whether one looks at the position before or after the changes to the CPR. We've set out the relevant principles in 100 to 102 of our case. If I can take you to the principles as after the changes in April, so changes to the overriding objective in 1.12F, go to the Walsham-Chalet case, that's at Authorities 2, tab 26. My Lord, halfway down the head note, the MS 1429, the Mitchell principles have a direct bearing on such an issue, so this is a 3.42C. The reason they have a bearing, by the way, is because of the change in the overriding objective in 1.12F, not because of 3.9. However, the ultimate question for the court in deciding whether to impose the sanction of strikeout is materially different from that in deciding whether to grant relief from sanction that has already been imposed. In a strikeout application under Rule 3.4, the proportionality of the sanction is in issue, whereas an application under Rule 3.9 for relief has to proceed on the basis that the sanction was properly imposed. And then at 44 on 1447, if my lords could read from the Mitchell principle down to the end of that paragraph.
Sorry.
That's MS 1447. So that was the position, my lords, after the change to the overriding objective. Prior to the change in the overriding objective, the principles are set out in the Baguzzi case, which is at tab 4 of the first bundle. MS 1101. Sorry, yes, MS 1101. So starting from under 3.42C, the judge has an unqualified discretion. The fact that the judge has a power doesn't mean that in applying the overriding objective, the initial approach will be to strike out statement of case. So that's the Court of Appeals approach. The advantage of the CPR over the previous rules is that the court's powers are much broader than they were. In many cases, there will be alternatives which enable a case to be dealt with justly without taking the draconian step of striking out. And then, my lords, if you go from D, there are alternative powers which the courts have, which they can exercise to make it clear that the courts will not tolerate delays other than striking out cases. In a great many cases, those will be the appropriate ones to adopt because they produce a more just result. In considering whether a result is just, the courts are not confined to considering the relative positions of the parties. They have to take into account the effect of what has happened on the administration of justice generally. That involves taking into account the effect of the court's ability to hear other cases if such defaults are allowed to occur. It will also involve taking into account the needs for the courts to show that, by their conduct, that they will not tolerate parties not complying with dates for the reasons I've indicated. But here, of course, all these applications were expedited so that the 17th of November 7-day hearing date was not put at risk. So, my Lord, the key issue prior to 1 April 2013 was effectively whether alternative sanctions were available. And as the upper tribunal found, the first-tier tribunal, for some reason, was under the belief that, in fact, it couldn't make an accosts award, and the upper tribunal corrected that in paragraph 63. BPP could also, of course, have promptly, after receiving the particulars on the 31st of January, said that it was not happy, instead of waiting 6 weeks, and then, without warning, seeking a strikeout. Now, BPP's answer to all this is to say that what we're doing is collapsing all the tests in 8.3 A to C into a single test. Well, we say we're not doing that. The tests may be different depending on the factors. But in any event, BPP otherwise fails wholly to address this point. Turning then to my third point, this is whether the Lord Reid's question, whether it's really correct in any event to apply directly civil procedure rules in the tribunals. Now, we have never said that civil procedure rules will be irrelevant. And traditionally, the tribunals have looked where there is an analogy to the analogy. But that doesn't answer the point here, which is that an amendment was made to the civil procedure rules. And should such an amendment have been read into the tribunal rules? We've set out our position in 63 to 87 of our case. The Court of Appeal simply took the view that there was no need for the tribunals to be amended in the way that CPR 3.9 and the overriding objective had been, for those same changes to have effect before the tribunal. In its view, the CPR changes self-evidently applied, and I'd like to take you to the Court of Appeal judgment for that. It's at MS 175 in the core bundle. And I want to take you, I've read you the first bit of 37 in BPP's objection to our notice of appeal, but going from 5 lines down, as to that policy, I can detect no justification for a more relaxed approach to compliance with rules and practice directions in the tribunals. And while I might commend the Civil Procedure Rules Committee for setting out the policy in such clear terms, it need hardly be said that the terms of the overriding objective in the tribunal rules likewise incorporate proportionality, cost and timeliness. It should not need to be said that a tribunal's rules, orders and practice directions are to be complied with in like manner to a court's. If it needs to be said, I have now said it.
I mean, the judge didn't in fact say that she couldn't deal with it by way of sanction in costs. She simply said that that wouldn't be adequate, unless I've missed something. I'm looking at paragraph 83.
83 of her judgment.
MS 275.
At some point she says that, she says costs won't compensate the appellant, but at some point she also says that the parties
no one suggests in this case that costs would be an adequate remedy.
Yes, yes.
She was asked the question. I can explain what happened. If it helps, I can explain what happened. Well, I'll deal with it in my submission.
Sorry, which is the relevant paragraph?
It looks like 83, doesn't it?
83.
Costs won't compensate the appellant. So he is puzzled why he believes, if I recall rightly what Judge Bishop says, I'm grateful, my lord, for that correction, that he says, it was, and I remain puzzled by the statement of Judge Mosdale's decision that neither party had suggested that costs would be an adequate remedy. That's at paragraph 83 of the upper tribunals. 63 of the MS 196. Yes.
But was he puzzled by it because somebody had suggested it, or was he puzzled by it because he thought that
Well, I
it would have been a
suppose
better idea?
his position in any event was that it doesn't really matter whether the parties think it's an adequate remedy or not. Case management decisions and ensuring the overriding objective is a matter for the first-tier tribunal, and costs could and would have been an adequate remedy.
That's actually a matter of evaluative judgment, isn't it? I mean, the judge wasn't expressing a view about the law in paragraph 83. She was simply saying that she didn't think that costs were adequate in this case.
Yes, and at a certain point, discretion becomes law in a sense, in that if that was manifestly unreasonable or wrong, then it was legally erroneous.
That's what you're submitting.
That is our submission, yes. Now, alternatively, so Lord Justice Ryder says it doesn't need to be said, and if it needs to be said, he's said it. That's what he says at paragraph 37. Alternatively, he says that since the upper tribunal is a superior court of record, it has the same powers as the High Court in relation to rulemaking, and there are no limits on those powers because of section 25.3, and he says that at paragraph 25 of his judgment. Now, BPP relies on these points at paragraph 55 of its case. We say they don't assist. First, of course, we don't dispute that the upper tribunal is a superior court of record, but that is no answer to the point. The changes made to the CPR 3.9 and the overriding objective were not made by the exercise of the High Court's powers as a superior court of record. They were made by the Civil Procedure Committee exercising its powers under the Civil Procedure Act, and they amounted to a substantial recasting of the rule for the reasons given by Lord Justice Jackson in his report on civil litigation, as set out in our case, paragraphs 53 to 56, MS 88 to 90. In the same way, we say that were such changes made in the upper tribunal, they would have to be made using the statutory procedure provided by Parliament as set out in paragraphs 42 to 51 of our case, MS 84. The Court of Appeal appears to have thought that the High Court could itself have made the changes to CPR 3.9 or the overriding objective wholly outside the statutory procedure, and we say that that would have been contrary to the intention of Parliament. Secondly, insofar as the Court of Appeal says that 25.3 of the Tribunal and Courts Enforcement Act means that nothing in the rules, tribunal rules, limits the power of the upper tribunal to amend the rules of the first-tier tribunal through guidance, we say that that is to miss the point. Our submission is not that the rules or anything else limit the upper tribunal's power. Rather, it is that the upper tribunal simply does not have power to legislate. And Section 25 is simply not relevant to that question. Of course the tribunal has power to give guidance on the interpretation of rules. That is part of its appellate jurisdiction, not its Section 25 jurisdiction. By the way, it's appellate jurisdiction. And BPP is wrong to say that we say otherwise, as it does at 56 to 58 of their case. Here, what the Court of Appeal was doing was importing statutory amendments to the CPR into the tribunal rules, and we say that that went further than providing guidance and usurped the statutory functions of the Rules Committee. BPP is wrong to say that the guidance didn't constitute effective amendment of the rules, as it does at paragraph 59. We've explained that in our case, at 78 to 81, as does Judge Bishop in the Leeds City Council case. We also want to take your lordships to the Eurotunnel case, where Mr. Justice Roth, President of the Competition Appeal Tribunal, took the same view as Judge Bishop, and that's Authorities 2, tab 28. And I want to take you, I've referred the relevant paragraphs in our case, but I want to take you to the last paragraph, paragraph 33, MS 1475, because Mr. Justice Roth notes there that there is a consultation going on in relation to the Competition Tribunal to amend the Competition Appeal Tribunal rules to incorporate the same changes as had been made to the CPR into those rules. And you'll see at footnote 2 a reference to that consultation. In fact, subsequently, the rules were amended. We have the draft copy here. If your lordships want it, I can perhaps leave it for you. It was section 3.2f. It became rule 4. So the rules in the CAT have been amended to reflect the amendments in the CPR, but the rules in the tribunal have not been. To conclude, we say that the starting point for interpretation purposes are the rules themselves, and the court must proceed on the basis that the difference between the tribunal rules, as we've set out in our case, and those of the civil court are intended. They are for a purpose. Judge Bishop and Mr. Justice Roth were correct to say that until amendments equivalent to 3.9 and 1.12f, no amendment should be read into the tribunal rules in the way that Lord Justice Ryder says he is entitled to do. Now, my Lord, turning to data select, my fourth point, I'm going to deal very briefly with it. We've dealt with it in detail at 88 to 95 of our case. The upper tribunal took the view at 55 that an appropriate test was the modification of its test in data select, and indeed that's very close to the Denton test expounded by Lord Dyson. Now, the Court of Appeal simply dismissed data select as irrelevant in paragraph 44, and in so doing it made several errors which we've set out in our case at 40. These errors derive from BPP's skeleton before it, which is at MS 1038, paragraphs 36 to 38, and indeed which BPP again repeat before you. They were wrong then, and they are wrong now. So my last point, factual errors in the respondent's case. We deal with these at 28 to 41 of our case. There are two crucial factual points in the case that the Court of Appeal got wrong, in the sense that the Court of Appeal directly contradicted the findings of the first-tier tribunal and the upper tribunal. As the Court of Appeal itself said at paragraph 11 of its judgment, there is no basis to go behind the conclusions of the FTT and the upper tribunal. It appears, therefore, that the Court of Appeal simply made two mistakes of fact reading those judgment. But we say those mistakes of fact were likely to be highly material to the approach they finally adopted. So the two mistakes were, first, what actually preceded Judge Hellier's order, and in particular, whether the Revenue had refused to agree a time frame, and secondly, whether, and if so, when, HMRC in fact remedied its breach. As to the first, I've already explained that the Revenue agreed to provide further information, and on the 17th of December agreed a time frame, namely by 31 January. The only reason a hearing took place at all was because BPP wanted an unless order, which Judge Hellier refused. The Court of Appeal was simply wrong, therefore, to proceed on the basis that Judge Hellier was making his order against the background of the Revenue refusing to give a date. and I'd like to take you to the Court of Appeal judgment in the core bundle. It's at MS 163, paragraph 5B. HMRC agreed to provide replies to each of the requests, but refused to commit themselves to a timetable for the replies. Consequently, in consequence, Judge Hellier made an order directing HMRC. That is simply wrong. Now, we express our concern that BPP should attempt to argue that the Court of Appeal was in fact correct. BPP knows that it was not correct, and the Supreme Court need only go to paragraph 15 of the agreed statement of facts and issues, which is at MS 63. On 4 December, FTT listed the application for 9 January. HMRC offered to provide BPP with the information requested by 31 January and asked for the hearing to be vacated. Now, at paragraph 15 and 50 of its case, BPP again state that HMRC refused to agree a time frame. That is, that the Court of Appeal was right. And we can go to MS 132. Paragraph 15, halfway down, HMRC criticised the Court of Appeal for stating at 5B that HMRC, etc. The criticism is misplaced. That is exactly what HMRC did. And then they refer to paragraph 9 of the judgment, which you can find at MS 264. And if you go to MS 264, you'll see that that relates to an earlier period, but that at paragraph 11, it is made very clear that by the end of December, the parties were agreed that the replies were to be provided by the 31st of January. Now, as to the second, also crucial point of fact, the date when HMRC remedied the breach. Now, you might find 13 and 16 is used. That's because the date of the skeleton is 13, but in fact, we only served it on the 16th. So I have used 16th throughout. For some inexplicable reason, the Court of Appeal found that HMRC could not rely on that remedy skeleton, and it says that in paragraph 13 of its judgment. It is manifestly clear from both the first-tier tribunal and the upper tribunal that that was a remedy for the breach. The paragraph, we've set it all out in paragraph 29 of our case, but for your note again, it's 70, 74 and 86 of the first tier, 24 to 25 and 51 of the upper tribunal. BPP didn't argue, and nor could it have, that the FTT and upper tribunal had been wrong that the breach had been remedied before the barring order hearing. On the contrary, BPP accepted in its grounds of appeal to the Court of Appeal that the FTT and upper tribunal had been correct, and that's paragraph 5.4 of its skeleton, which is at MS 1030. And I note in passing that BPP also accepted before the upper tribunal that, quoting from the upper tribunal judgment, it has been possible to agree on the relevant facts, and the hearing fixed for 17 November has not been lost. That's paragraph 52 of the upper tribunal judgment. We are surprised, therefore, that BPP is trying to argue in front of this court that the Court of Appeal did not get this fundamental point wrong, and indeed appears to be trying to adopt this error as a new finding of fact. And we refer the court to 3 points. First, BPP in its notice of objection to our permission to appeal application at 3.4 MS 55 seeks to adopt this error, that there may never have been compliance. Secondly, BPP refused to allow the findings of the FTT and upper tribunal that we have set out in paragraph 29 of our case to be in the agreed statement of facts. And thirdly, now, before this court, BPP contends that the Court of Appeal made no mistake, implying that the breach was not remedied. And that is at 47 to 49 of its case, MS 140. To conclude, my lords, we say that it is clear from its conclusions on the fact that the upper tribunal properly exercised its appellate jurisdiction in overturning the decision of the first-tier tribunal, whilst the Court of Appeal, in overturning the upper tribunal decision, did not. The upper tribunal properly found that the first tier had erred in believing itself obliged to give significant weight to the need to comply with rules, i.e. follow Mitchell as applied in McCarthy, rather than the Denton test. Secondly, it held that in any event the breach was not sufficiently serious to meet the first stage of Denton. And in any event, looking at all the facts and circumstances, that the barring order was unreasonable, whether one applied data select or Denton, including having regard to factors that the FTT did and didn't have regard to. The upper tribunal, we say, properly concluded, exercising its appellate jurisdiction, that the barring order manifestly should not have been imposed in this case. Those are my submissions, my lord.
Thank you very much indeed. Thank you, Ms. Simon. Mr. Gibson. We'll retire to consider where we've got to. We'll return very shortly. The court for the moment is adjourned. Mr. Kosinski, it seems to us that whatever the Court of Appeal may not have done or may have done right or wrong, the issue ultimately is whether the first instance tribunal judge, Judge Mosdale, was entitled to reach the conclusion that she did, whether she went wrong in law, and if not, whether she reached a conclusion which was one she could not reasonably have reached, a proposition which I think Ms. Seymour accepted. We also have to remember, as Lord Reid implied when he asked Ms. Seymour some questions, that we are concerned here with a tribunal that is potentially has rules which apply across the UK, not just in England and Wales. But when we look at the decision in tab 26 of volume 2 of the authorities, the Walsham-Chalet case, particularly at page 1446 and 1447, to which Ms. Seymour took us, Lord Justice Richards there distinguishes, again looking at it from an English point of view, between CPR 3.4 and 3.9. So far as he's dealing with 3.4 and 3.9, do you accept what he says as a fair summary?
My lord, the difficulty about drawing any precise analogies...
Now, I'm not asking you for analogies. I'm saying concentrating on 3.4 and 3.9 before we get to analogies.
Well, what he says there is obviously concerned with the CPR.
I know. I'm asking
under the first-tier tribunal procedure rules, there is provision in Rule 8.3a, which we haven't yet looked at, to give a warning to the party who has been in some form of default, that if they fail to comply with the order, they may be debarred or struck out, as the case may be. And a critical factor in this case, which was at the forefront of Judge Mosedale's analysis, but with respect to my learned friend is singularly lacking in hers, is that that is what had happened. There had been conduct by HMRC which had led Judge Hellier to impose a Rule 8.3a warning order.
But he put a warning order rather than an unless debarring order.
He did, and my Lord, if my Lord permits me to, I will make some submissions a little later on about the principled difference, if any, between a Rule 8.1 order.
I think we'd like to concentrate on specific issues, so I think if you could deal with that now, that might be helpful.
The 8.3a my Lord, can we
Sorry
turn...
to take you out of order, but I...
No, can we turn to the rules?
Yes, of course.
In the slim spiral-bound volume.
Yes. Yes.
Rule 8.1 at MS 11 internal page 6
Yes.
allows or provides for the automatic striking out of a party, or in HMRC or a respondent's case, they're debarring, where they have failed to comply with a direction which said that the consequence of non-compliance would be the striking out.
Yes.
8.3a provides for the warning order of the kind that was made by Judge Hellier in this case. Judge Hellier's order expressly said, if HMRC do not provide all the particulars that they have been required to provide by the 31st of January, they may be debarred.
So on the one hand, there's will be, on the other hand, there's maybe.
Maybe.
Yep.
And my principal submission is that even though one provides for automatic striking out or debarring, and the other provides for discretionary debarring, there is no presumption that a party cannot expect that he or it will obtain greater leniency for breach of an 8.3a warning order than he will in an automatic debarring context.
I think the point being made in the Walsham-Chalet case, and I absolutely accept that it's concerned with the CPR and here we're concerned with the rules, but nonetheless the point might be said to be apt, is that in the first case, an 8.1 order, the court has decided that a debarring order would be appropriate if you don't comply, and therefore, if you don't comply, the debarring order is, as it were, taken for granted, subject to relief from sanction.
Indeed.
In an 8.3a case, you're warned that you might face, or you may face, a debarring order.
Yes.
So the merits of the debarring order fall to be considered.
Absolutely.
That's really the point being made by, I think, Lord Justice Richards. While you're absolutely right that we have to look at the rules of the tribunal here, do you accept that's a fair distinction?
I do, my Lord, but that is precisely the distinction that Judge Mosedale herself drew. And if my Lords turn to the FTT's decision, which is at Appendix Part 1, Tab 11, and my Lords look at, starting at paragraph 64, after Judge Mosedale considered Mitchell.
Yes.
And what MS page is that?
272.
272.
At paragraph 64, Judge Mosedale said that while Lord Dyson said that these two factors were of paramount importance and that other circumstances should be given less weight, nevertheless, even where CPR 3.9 was concerned, it was clear he did not mean that these two factors would always outweigh other factors, as CPR 3.9 itself said all relevant factors must be considered. And if my Lords then turn forward, please, to paragraph 95, or perhaps starting at 94, Mr. Singh, who at that time was counsel for HMRC, put weight on the fact that the appellant had sought a Rule 8.1 order, whereas Judge Hellier only imposed a Rule 8.3a order. I consider the fact that the appellant unsuccessfully applied for an unless order is irrelevant. What matters is that Judge Hellier did impose a Rule 8.3 order. He did not consider it appropriate to impose Rule 8.1, but that does not carry any kind of implication that he didn't intend the tribunal to strike out HMRC if there was non-compliance. He intended the tribunal to have a discretion, and that is the discretion that I exercise. But then critically at 95, there is no presumption that I will order HMRC to be barred. I must simply weigh all the factors. If I am in doubt whether barring is appropriate, I must err on the side of not barring HMRC. And that is fundamentally incompatible with the submission by my learned friends that somehow Judge Mosedale wrongly applied the Mitchell approach and started off with the assumption that she had to enforce the sanction.
If I can just interpose, that's very helpful, because what I was going to put you next was that when you then come to the conclusions, can it not be said that that the judge has failed to take anything into account other than the failure to comply with the rules and its effect on the other party, on your clients? Because if you go through what she says from 95 onwards under her conclusions, although she says she must take into account all the factors, the only factors she refers to, it may be said, are the procedural factors, as it were, rather than the consequences for HMRC of disbarring.
Well, my Lord, that would be to ignore the prior 30-something paragraphs of her decision. If my Lord turns back to paragraph 65, she says, I conclude that in considering whether to grant the appellant's application to bar, I must consider all the relevant factors. I will include in my consideration factors A and B and accord them significant weight. I'm going to come back to that in a second. As part of my consideration of the overriding objective. Now, effectively, HMRC's case collapses into a submission. When she said she had to accord them significant weight, that was an error of law. But given that they say self-evidently the need to comply with rules and orders is a matter of relevance, it's an ambitious submission to say that a relevant factor, indeed a self-evidently relevant factor, is somehow insignificant, and that to place significant weight on it constitutes an error of law. And then she went on to consider all the relevant factors, including the effect of the non-compliance, the prejudice to the appellant, the reason for the default, the ongoing administration of the appeal, and, critically, at paragraphs 83 onwards, the main point relied upon by my learned friend, that barring was a draconian remedy, and at 88 to 90, the importance of the case to HMRC. So it is clear from all those paragraphs that she did indeed consider all the relevant circumstances and not just the simple fact of the breach.
Does she anywhere consider whether the facts were, despite all that, that nevertheless there could still be a fair determination of the underlying issue?
Well, my Lord,
does she grapple
that is the issue that was grappled with by her at paragraph 85, or paragraphs 84 and 85. So counsel for the revenue didn't suggest there was an alternative sanction. Can I just pause there, just to deal with, while I'm there, with the question of costs? Judge Mosedale asked counsel for HMRC, do you say that costs will be the relevant alternative sanction? And he expressly disavowed that. His solution instead was that the appeal should simply be allowed to proceed because barring was too draconian a remedy. And he said, as is recorded in paragraph 85, that the tribunal should only bar HMRC where the breach was incapable of remedy or had not been remedied. In other words, where nonetheless a fair hearing was still possible. And if my law, and that takes me to my point on Rule 8, or back to my point on Rule 8.3.
Yeah.
If my lords turn to Rule 8.3b, you see that in addition to the Rule 8.3a power to debar when somebody has breached what I call a warning or conditional order, there's a Rule 8.3b power allowing the tribunal to strike out or debar where the appellant has failed to cooperate to such an extent that the tribunal cannot deal with the proceedings fairly and justly. So the draftman of the rules clearly contemplates that there will be occasions when it will be appropriate to debar a party because of their procedural misconduct, particularly their failure to adhere to a warning, even though the tribunal could still go on to determine the substantive issue.
I follow that, but some of us might think that the whole point of litigation is to determine cases on their merits, and that's the underlying thing which cases are really about. And that you need a very strong case. If you can still determine the issue on its merit, you need a strong case to strike it out on procedural grounds if you can still have a fair hearing of the underlying dispute and if there are cost sanctions and the like.
Well, my lord, if the approach is one must always forgive a party for a breach of a procedural order, unless the...
No, I wasn't suggesting that at all. I was suggesting, however, that it nevertheless is a draconian step to take and should be taken as pretty well the last resort.
Well, I have 2 points in response. My lord, first of all, Judge Hellier's order had warned HMRC that they faced that draconian step.
Well, all that says it could lead to it.
Well, could I invite my lords to turn up Judge Hellier's order? It's worth having...
Whatever Judge Hellier thought, what the rule says
Yes.
is all you've got to show is that it could lead to the striking out.
My lord,
That's what the
yes.
order says.
My lord, yes. I accept that.
And that's only a small step along the... It may be irrelevant and turn out to be a critical step, but nevertheless...
Well, my lord, the critical point under the rules is that this is not the breach of any practice, direction or rule. It isn't as if, for example,
No, it's all a question of the underlying merits of the dispute.
No, but my lord, it's not as if HMRC had been directed to provide FMBPs by such and such a date, had failed to provide them, and then had been debarred. They had failed to provide them. My clients had chased and chased. Eventually, after a contested hearing, Judge Hellier said, you must provide them by such a date, and if you do not, you risk the sanction of being debarred. There was no appeal from that order, and no one seeking to go behind it. So faced with that, the question is, in circumstances where there had been a breach, and no one is now contesting that there had been a breach, where there had been a breach of that requirement, and HMRC had been warned, and as she did, Judge Mosdale in paragraph 83 recognised in terms that barring is a draconian remedy. I go back to the observation made by my Lord Neuberger at the start, but the question is, did she either fail to take into account a relevant consideration or in law? And in circumstances where she herself was careful to distinguish this case from the Mitchell approach and was careful to say, as she did at paragraph 95, that if there was a balance to be struck and there was any doubt about it, she should err against debarring. How can it be said, I ask rhetorically, that there was any error of law by placing too much weight on any particular factor?
Do you want to ask?
No.
Well, thank you very much, Mr. Brzezinski. I don't think we need, unless there's anything you're dying to tell us, I don't think we need...
That rather depends, my lord, if there's any outstanding concerns that my lord
If there was, we would have asked you.
I'm grateful.
Otherwise, it would have been spectacularly unfair. Yep, thank you. Ms. Summer.
My lord, if you will allow me, I would like to...
Do you want the lectern? Sorry.
If I may just take you first to the notes, I meant to take you to 3.9, core bundle 249, MS 412.
Yep. Yes.
Starting in the paragraph that says, it should be noted.
Yes, that's the last one before the break of the new title.
Yes, it should be noted that 3.9 comes into play not merely where a party has failed to comply with any rule, but where a sanction is imposed as a result of that failure. No sanction is imposed, for example, where a party fails to comply with 3324A, a provision imposing a time limit for service of hearsay evidence. Consequently, on an application to extend time in this case, neither 3.8 or 3.9 applies. The court does have power to impose a sanction for non-compliance with any rule, practice, direction or court order, i.e. the power to strike out a statement of case under 342C. However, in any particular case, the exercise of this power might be disproportionate and so would not achieve the overriding objective in 1.1. In many cases, the court should consider imposing some lesser sanction as a more appropriate alternative to strikeout, and I took you to the Baguzzi case. Now, here, Judge Mosdale did not look at the proportionality of barring. Rather, she asked herself whether costs were an adequate sanction. And as Lord Clark said, she ignored the fact that by the 16th of June, BPP had had all the facts it said it needed, and indeed, on the 27th of June, the parties agreed facts. I didn't take you to it, but I'd like to. It's in the second appendix, 2B.
The whole of the section under the heading Draconian Remedy, paragraph 83 and following, is in fact addressed to proportionality, isn't it? May not use the word proportionality, but that's what it's doing.
Yes, well, she says the case has been unnecessarily delayed by 8 months. That, of course, is incorrect because the timetable was kept to, the Helier timetable was kept to, and the case was not delayed in any way at all. The hearing was fixed in March for 7 days in November. By the 16th of June,
I'm sorry,
the
my
parties...
lords. I'm somewhat concerned that my learned friend, in the context of a reply, is now seeking to make points on the facts which I've had no opportunity to address.
Well, if we need you to address us on them, will give you the opportunity.
I'm grateful.
So by the 16th of June, as is clear from the first-tier tribunal and the upper tribunal, and it was accepted by BPP, it had all the facts it sought. If we then go to Appendix 2B, tab 100, the parties on the 27th of June, and perhaps I can give you the chronology, of course we've set it out in detail.
We've set out the, but
Tab 100.
What point is this exactly going to? I think Mr. Brzezinski is right that this doesn't really arise from his submission.
Well, it goes to Lord Clark's point that by the 16th, and certainly by the which preceded the barring hearing, which was on the 23rd, and certainly by the 27th, when the parties agreed this statement of facts, the case was ready to go in the sense that the facts were there.
Did the judge say it wasn't ready to go?
The judge did not deal with this crucial issue which Judge Bishop dealt with, which Lord Clark pointed out.
Right.
Was there any prejudice to the hearing being heard properly and fairly? And this, I remind my lordships, is what Judge Bishop said was the most important factor, and why he said that Judge Mosdale had simply made a manifest error, because the most important factor was that by the 16th, the breach had been remedied, and certainly by the 27th, the parties had agreed the facts. Now, I'd like to take you also to our letter, which we wrote to BPP on the 1st of August.
Could I just clarify with you, there was, as you say, at page 695 in Appendix 2B, tab 100, a statement of agreed facts.
Yes.
Is it HMRC's positions that those were the only facts, or were there going to be witness statements covering other facts?
I'm not sure there were witness statements as well. I believe there were witness statements of fact. But
So
There were no witness statements served. There
There
would
were
have
no
been, but there weren't.
no, but there was an opportunity. There was an opportunity, notwithstanding the statement of agreed facts agreed on the at the end of June. There was still an opportunity for parties to produce witness statements.
we'll look at Judge Hellier's order. But certainly what is undisputed is that by the 16th of June, the breach, that is the failure to provide adequate responses on the 31st of January, had been fully remedied. And no one can dispute that. It's found by both the first tier and the upper tribunal.
Yes, but if the first tier found that, then they didn't ignore that point. I mean, paragraph 74 of the first tier, under prejudice to the appellant, it being BPP, accepts that since Mr. Singh's skeleton was served, it now knows HMRC's case, but it knows it late, and therefore what the judge thereafter does is focus on the delay.
Yes.
So yes, it focused on delay and it concluded wrongly on Judge Bishop's analysis that costs could not remedy that delay. The only breach was delay. It had no effect on the ability of the first-tier tribunal to hear this case fairly, and therefore, by definition, it could be remedied by way of a costs sanction. And I'll take you to that, but I was just going to take you to our 1 August letter.
Well, why are you taking us to the letter, Ms.
Because in the letter, we make it clear to them that there is no prejudice now on the 1st of August to the November 17th hearing, and therefore...
This is reopening a new case, but it's not. What you're saying is, ultimately, that she ignored this factor, which was in the, which is what you say Judge Bishop said anyway. I'm not really sure where this is going.
Yes, well, it's Judge Bishop, in reanalysing all the circumstances, considered that the most important factor, and I would submit that that is beyond a discretion issue. It was an error of law for Judge Mosedale to ignore or to not give significant weight, effectively, to the fact that nothing that had happened prejudiced a 7-day fixture which had been fixed in March.
Well, I don't think we need to look at letters for that. We have.
All right. My point really was that the BPP were informed that there was no. Well, perhaps I can stop on that point. But perhaps I can take, just to answer Lord Hodge's question,
yes, of course.
In Judge Hellier's order, which Lord Hodge can find at MS 307, paragraph 10 specifically provides that witness statements may be given by mutual exchange at the latest on 31 July. And you may recall that Judge Mosedale says in her judgment that the delay has made it impossible to serve witness statements.
Yep.
But of course, the order was 31 July, and by 16 June, the breach had been remedied. So it did not make it impossible. Now, turning then to the question of whether costs could remedy the prejudice in any event was only delay.
Yes.
And
Well, this is what she says in paragraph 83.
yes, and we say it was an error of law, as found by Judge Bishop, to say that prejudice, bearing in mind the fact that it had no impact at all on the 17 November hearing going ahead, could and should, applying a proportionate approach, whether Data Select, 3.42c or Denton, be dealt with by way of a costs order. Now, I don't perhaps need to give you all the references. I have all the references in relation to prejudice, but I don't believe there's a dispute between the parties that the only prejudice was the delay.
Well, that's what she says in paragraph 83.
Yes, and the costs incurred in chasing HMRC. Necessarily, they could have been dealt with by way of a costs order. And as Judge Bishop held, it was manifestly unwarranted in such circumstances to impose a barring order.
I understand that. But, so the 2 points, as I understand it, you're making is, first of all, picking up what Clark says, she doesn't take into account the fact that the breaches had been, as it were, remedied and the matter was ready to go. And secondly, the only problem caused was that of 8 months' delay, and so far as there was any cost implication, they could have been put right by an order for costs.
Precisely.
Yep, okay.
And so the paramount issue was, could the hearing go ahead?
Is there anything else you wanted?
Just one further. At paragraph 57 of the Upper Tribunal, we see what Mr. Grzyński was describing as the prejudice. He says, there is a countervailing imperative that a trader, such as BPP, should know where it stands. It is in competition with other traders which supply its books to students, some taking BPP courses. Because they supply only books, those traders can zero rate their supplies. BPP is subject to uncertainty, this is its claim of prejudice, and the longer the appeal takes to conclude, the longer that uncertainty. Well, I ask your lordships to look at the reality of this case. The reality of this case is that had BPP gone ahead with the hearing and not lost 7 days of fixed hearing, which presumably went to nobody, it would have known the status of its supplies by the end of 2014.
Thank you. Mr. Grudzinski, very briefly, I think in fairness to you, I think the point, it may be that there's something you want to say in reply.
Maybe that there is.
Insofar as there's a new point.
Just very briefly, to address the submission that Judge Mosedale ignored the fact or the factor that the breach had been remedied, that can be addressed by looking at her decision at paragraph 86, where she says, I consider the fact that the breach was remedial and was, in fact, eventually remedied does not preclude the tribunal from barring HMRC. A large part of counsel for HMRC's submissions at the hearing before her were directed to the very point that is now said to have been ignored, namely, well, we can go ahead and have a trial.
I'm not so sure it said it's been ignored, but the point made by Lord Clark, which I think you answered, is that it's disproportionate, effectively.
Yeah. I've addressed that. The only other point to address is my learned friend's submission that this was essentially a one-off breach and that the tribunal, namely the first-tier tribunal, was somehow in error in describing it in any other way. In fact, far from it being a one-off breach, there were a series of other procedural failings. Just to give you the references, in the first-tier tribunal's decision, they are described at paragraphs 81 to 82.
Yes.
And in the upper tribunal's decision, it may be worth just turning that up briefly.
Well, she makes the finding that they didn't appreciate. It's really all in paragraph 82, isn't it?
It
While
is.
none of these delays are particularly significant, HMRC does not appear in this appeal to have appreciated the importance of adhering to the
And indeed, that is expanded upon significantly by the upper tribunal at paragraphs 48 through to 51, which I'd invite you to look at in
Very well, we'll look at those. Thank you very much. Well, we're very grateful to counsel for their submissions. We're also grateful for the written cases. We and all those who contributed to them, we will consider our decision and let you know in due course. Thank you very much indeed. Court's now adjourned.